How's everybody doing? Joe Pastore with Platinum Method Coaching, and today we're going to start our section on divorce and custody. And this segment we're going to do today, it's just going to be an introduction and an overview, so I'm going to give you some information, and then we're going to build on it. So, one day you wake up and you realize the romance is over, your marriage no longer works. So you start to think about ending the relationship and all the implications that go along with it. And immediately all kinds of thoughts start to run through your head. How is this going to impact my children, my life, my finances? Where will we live? Will the children live with me, with my ex? Will I lose my children? Will I have to go through a custody evaluation? Should I fight for custody? Should I just settle for whatever offer is presented? How much is this going to cost? If we disagree, will I be able to get a fair custody arrangement? How am I going to deal with all the negative emotions? Where do I start? It's very easy to quickly become overwhelmed with the magnitude and the consequences of the decision and the realization that it's going to impact virtually every single area of your life. Now, divorce is up there with the death of a loved one, job loss, moving, and of course ending a relationship as one of life's most stressful events. In fact, with divorce, you get a bunch of all of them rolled up into one perfect storm of stress that can test even the most well-grounded people. And while some people thrive on stress, most make less than perfect decisions under such demanding circumstances. So during a divorce, you're experiencing many powerful emotions while attempting to comprehend the fallout of ending a relationship. Possible loss of your children, your home, and the financial carnage that can follow. It's a difficult state of mind for making well-thought-out decisions, and common sense becomes scarce. And then it becomes magnified that if you make bad decisions here, it could haunt you for the rest of your life. It's been said that there are as little as 6 days or events that define the entire course of our lives. Divorce is definitely one of them. I've gone through 2 divorces and subsequently 2 custody evaluations. I didn't request either, but was awarded additional custody as a result of each. Now you may notice I didn't use the word win, and that's because nobody really wins custody. But if you focus on what's important, which is your children, you take the high road and then you're successful, both parents are going to be given the opportunity to do what's best for their children. And hopefully, you'll both rise to the occasion. I want to share with you the lessons that cost me hundreds of thousands of dollars in legal fees and years to learn in an effort not only to reduce your legal bills, but also to preserve your children's mental health and help you retain your sanity. And you can't put a price on that. Have you ever heard the saying, if you think education's important, try ignorance? Or, it's much easier to raise a child right than trying to fix a broken adult? Well, in order to help you avoid these pitfalls, I'm going to cover the key areas that you're going to need to know about if you want to have shared custody. Throughout all these courses, these presentations, these segments, I'm going to randomly alternate between the word child and children, so it means both. I'm going to guide you through the custody process and give you the strategies for obtaining a fair, practical, and well-thought-out custody agreement. I've also included a list of mistakes that parents make during divorce and custody and how to avoid them. I'm going to reveal this later on, along with important techniques to influence children to want to spend more time with you. Now let me stress this right up front. Nothing is more important than your children. Your primary goal should be doing what's best for them. If you start with this premise and work backwards, things are going to fall into place. Don't focus on timeshares or support payments, because every decision you make should start with the premise of doing what's in the best interest of your children, what's best for them. Take the time to create a custody agreement that works for both the children and the parents. The more you compromise and work together, the better off you're going to be, and the better off your children are going to be. The more you fight, the more you prolong the process, the more your children are going to suffer, and the more expensive the process is going to become. Be smart, Put your ego and your emotions aside. Ask yourself if you'd rather use your savings for your children or for your attorney's children. Now let's start examining what custody entails and what's going to have to be done to make it win-win for all of you. You have to protect your children from becoming casualties of divorce as much as possible. It's critically important to your children's mental health that you allow them to love the other parent and reassure them that they're loved. Clarify to your children that divorce is not their fault. David Kuroda of LSSW, he's working for over a decade as a social worker, counselor, and mediator. He's helped some 8,000 families navigate through the stress of separation and divorce, and he's seen firsthand that dividing a family is never easy, but it doesn't have to come at the cost of the children's well-being. It's not that the divorce hurts the children, he says, it's the way that parents get divorced and the amount of conflict between them. That's what harms children. Now, David shared a few tips about couples with children and how they can uncouple in healthy ways. In 2017, he wrote an article in the USC Trojan Family Release entitled, How Parents Can Help Kids Deal with Divorce. And I'm going to read an excerpt from it. One of the points that he makes is, tell the children that divorce is not their fault. Remind them as often as you need to do this. Reassure them that you'll always love them. Next, even if you're worried about money and feel uncertain, remember that as parents, we have to give our children hope for the future. You might tell them that you may live in a smaller house, you may not take as many vacations, but that you'll continue to love them and you'll be a family no matter what happens. Love your children more than you hate your soon-to-be ex-spouse. Put your children's needs first, and don't make them feel like they have to choose sides. One more point. Even though the courts can't require payment of college tuition fees, parents sometimes include this in their arrangement. So stay consistent about your expectations for school. Try not to let sympathy and sadness persuade you to allow your children to skip their schoolwork or to take it lightly. I'll put this in the resource section so you can look at all the points that David makes, but you're starting to get the idea. So, we realize we're getting divorced. One of the first things we need to do is assess the situation. Now, in terms of custody, what are your assets and what are your liabilities? What role do you currently play in your child's life? Are you the primary parent, or does the other parent take care of most of the child-related responsibilities, such as getting them ready for school, driving them to activities, doing homework? How are responsibilities currently divided between you and the other parent? Once divided into two separate households, how much time can you reasonably expect to spend with your child? What does your work schedule look like? Is it flexible? If you get a call from school because your child is sick, can you get there? And if so, how quickly? Do either of you have substance abuse problems? Is there any history of domestic violence? Do you have good rapport with the children? These are just some of the questions that you need to start asking yourself to determine where you are in terms of how a court is going to look at you as a parent with regard to custody. In another segment, I'm going to go over the differences between physical, legal, joint, and sole custody in detail. So we'll get to that. Now, virtually everything's going to change once there are two separate households. Are you going to have the flexibility to be the primary custodial parent? And is that what you want? What's your ideal outcome? Do you want joint custody? Can you and the other parent make it work? We all want to enjoy our children and do what's right for them, but do you have the time and energy to be there for them when it's necessary? Make sure you can answer all these questions and understand the ramifications and commitment of being there, and be reasonable. The following is going to give you some perspective on background and the outcome of custody cases over time. So let's do a little history. Joint legal custody statistics from 1997, gathered from 19 states, found that joint legal custody is awarded to 2 out of every 10 divorce cases involving children, which is not that much. More than 70% of all custody cases result in the mother receiving primary physical custody of the child. Less than 10% of all child custody cases result in primary physical custody being granted to the father, and joint legal custody would rarely be awarded. Initially, there was the tender years doctrine, which the courts adhered to the philosophy that during the child's early years, tender years, it was more beneficial for them to be with their mother. And over time, the tender years doctrine was replaced by the best interest of the child standard. Bring up to today, joint legal custody is very common in child custody cases in most states. Usually, a family court will award joint legal custody if it's requested by both parents, unless there's a persuasive reason why one parent should not be involved in the decision-making process. Now, let me be clear about this. This varies tremendously from state to state, but this is clearly the trend, and most states want to get to this position. So what are some common custody arrangements? Sole custody is the most common type of physical custody arrangement, according to an older study posted on divorcepeers.com. Where parents mediate, sole custody occurs 69% of the time, 63% for the mother and 6% to the father. When a child custody case goes to trial, sole custody is ordered 55% of the time, 44% for the mom and 11% for the father. Joint custody occurs around 25% of the time if parents mediate, and 40% of the time if they go to court. Family courts prefer to award joint legal custody, even if sole physical custody is awarded. Now, the reasoning for courts awarding joint legal custody is that it gives both parents a parental voice into the upbringing of the child. Whether to award joint physical custody or not depends a lot on the living arrangements of the parents and the children. Now, to make joint custody work, it's imperative that the parents are able to communicate effectively with each other about issues regarding the children. If parents are able to co-parent for the benefit of the children, it's likely to be the best situation for the child. Now, if it happens to be a high conflict situation, however, then they might consider parallel parenting, which we'll get to another time, as a way to communicate. Remember, this is just an overview. I'm going to get a lot more into these terms a little later on. So, you're asking the big question. Is a mother more likely to get custody than the father? Well, statistics from the U.S. Census show that mothers are 4 to 5 times more likely to have sole custody of the child than the father after a divorce. Now, the reason for this difference is, in mediated uncontested divorces, parents agree that the mother should have custody 63% of the time, while parents agree that the father should have custody only 6% of the time. In both contested and uncontested divorces, fathers want custody only 33% of the time, while mothers want custody 88% of the time. Now, because fathers typically are the primary income source, they tend to be more career-oriented than mothers, which can lead to the courts finding that mothers with more free time are the best option for the child custody. Makes sense. And because women are more likely to initiate a divorce than men, they're more likely to be prepared for the divorce litigation than their male partners. Now, this unpreparedness can lead to men signing settlement agreements that lead to them not getting the same custody agreement that they might get if custody cases were litigated. Mediation allows both parents in a divorce to work out the details of their divorce decree together, with a family court having to decide. Now, the advantage of mediation is that it gives both parties control over the wording of the divorce decree. Now, once again, according to DivorcePeer's statistic, when parents mediate, mothers get sole custody 63% of the time, while fathers only get 6%. Also in mediation, the parents will elect to have joint custody 25% of the time. Contrasted with going to court, mothers get sole custody 44% of the time, and fathers get sole custody 11%. So joint custody is awarded 40% of the time if the case goes to trial. What means this? This demonstrates that fathers typically decide they don't want to fight for child custody when they mediate. Why this is the case is unknown, but here are some possible reasons. Parents who mediate may have one lawyer involved, and that lawyer is only able to represent one party. The person who does not initiate the divorce is not usually prepared to litigate for child custody. Mothers typically initiate divorces. According to a study done by the AARP, 66% of the women who are divorced say they were the ones who asked for the divorce. A father who's career-oriented might decide that the best thing for the children is for the mother to get custody during the week, while the father gets visitation on weekends. Now this is changing, but once again, we're going over history here. A father might simply assume that they're unlikely to win custody in court, so they just tend to settle. Now, how does going to court affect who gets child custody after the divorce? Ironically, going to court reduces the number of custody arrangements where the mother is the primary custodial parent. In other words, fathers who mediate will typically not get sole or joint custody, while it's still much more likely that a mother will get custody if a child custody case goes to court in a contested divorce. Chances of a father getting custody almost double when compared to mediation. So, if a father wants to fight, oftentimes he's going to win. And that's really what it boils down to. If you want it, you're prepared to fight for it, you'll be effective. Now here's another, I don't want to call it a myth, but something that we believe, and something that's near and dear to my heart as well. Are the courts biased against fathers in child custody cases? Often the question of bias by judges is brought up because of the discrepancies between men and women getting custody. Makes sense. But to understand if the bias is not occurring, it's first necessary to understand what methodology the court uses to evaluate custody decisions. Now, the best interest of the child doctrine is the standard used in all 50 states, including Washington, D.C. Best interest of the child standard has replaced the tender years doctrine, which presumed that a child was better off raised by the mom. Now, even though courts shifted from tender years doctrine, many people, including some fathers' rights group, argue that the courts remain in the mindset of the tender years doctrine. Now, it would be impossible to say that bias does not take place. That would be like saying nobody in the United States remained prejudiced after the civil rights movement. The real question is, how significant is bias towards women by the court in determining child custody? To possibly be biased, the court must obviously be in a position to decide on a child custody case. Many cited statistics don't take into account the number of custody situations where parents mediated. Now, looking at statistics simply show how many mothers versus fathers have custody and doesn't provide really an accurate indication, because most child custody decisions are mediated via uncontested divorce. But looking at trials only, a father will be awarded custody 25% of the time that a mother would. Bias is one possible explanation, but not the only one. So the best interest doctrine forces courts to evaluate how much time each parent will be able to spend with the children. If the father has a career that takes him away from the children more than the mother, it's likely to hurt his chances of getting custody. Also, if the father is not the initiator of the divorce, he may still be going through a grieving process, while the mother is seeking legal counsel and preparing for divorce litigation. Both of these reasons can lead to fathers not becoming the primary custodial parent without court bias actually being the cause. Finances. Setting up and maintaining two households may cost virtually double the cost of one household. If you're the primary wage earner, then there's a high probability you're going to be paying support, and the court does not take into account your expenses. Therefore, you may be required to pay so much that it's impossible for you to maintain your previous lifestyle and spending habits. In fact, it's probable, I'll go so far as to say, in most cases. So in all likelihood, both of you are going to have to change your lifestyle, create a budget, and reevaluate all your expenses. Now, in most states, the more custodial time you have with the child, the less you're going to pay, or the more you're going to receive in support. So for this reason, even not equipped to handle it, most parents are going to ask for more time with the child. And it's horrible, but that's the way it is. But assuming it's now costing you approximately twice as much to live as prior to separation, how much can you afford to put towards lawyers for custody and divorce-related issues? If you have a high level of conflict, it can go into the hundreds of thousands of dollars. And the sad truth is that Many couples in high conflict divorce who are reluctant to compromise are going to end up filing for bankruptcy. Now, lawyers know this. Oftentimes, they do little to reduce the level of conflict. We'll get more into this in another section, but you need to start planning for financial survival. It's simply a fact of life. Even if it means you have to spend less time with your child and pay more in support. Your single largest expense in divorce may very well be your legal bills. So don't underestimate the cost of fighting or prolonging the process and the negative impact it's going to have on both you and your children. If the divorce goes on for 4 years and your legal bills average $4,200 a month, that's going to be over $200,000. And if you live in a large city and you have combined income of over $100,000, this is it's not an unusual scenario, let's just say that. Now, if you don't adapt your budget and your spending habits, the simple fact of the matter is you may not survive financially. And the sooner you realize your financial reality has drastically changed and you need a new, realistic budget, the better able you're going to be to adapt to a new expense structure. So a good financial plan will help you make the best use of your custodial time. You should ask yourself about every contested issue. Is it worth fighting over this if I end up having to file for bankruptcy? Whose plate it is, whose stereo it is, whose couch it is. Is it really worth filing bankruptcy over? Anyway, next, think about scheduling and be realistic. Be honest with yourself. When are you available to be with your child? What time do you get out of work? Can you pick up the children from school and get them to activities? How does this contrast with the other parent's schedule? Do either of you have family or friends who can pick up the child? Will there be a need for daycare? What about holidays and vacations? Can you alternate major holidays? You're going to need to create a worksheet of when you're available. In the appendix or in my resources, I've included a sample parenting plan and timeshare worksheet, which you should complete before proposing a custody schedule. You should carefully think through the scheduling process. This will be the most challenging part of custody. Be honest, be realistic about what's best for your children, what works for you, and what works for the other parent. And I know it's an emotionally charged time, so it's difficult to see that. And a lot of people realize that the more time they have with the kids, the more they receive in support or the less they pay in support. So they let this be an overriding factor when it really shouldn't be. It really should be what's really best for them, what's best for me. And more time in an idealistic world should be best, but it isn't always. So you have to really, really be honest about that with yourself. Okay, getting organized. Now we're going to talk about a little logistics. Throughout the divorce process, you're going to accumulate a lot of paper, charts, schedules, legal documents, just to mention a few. And you need to remain organized. So it's helpful to put together binders with blank tabs which you can write on. I recommend one binder just for court documents, as they're going to accumulate and you're going to need reference them from time to time. You should also create a second binder for custody-related documents. You should include a preparation checklist for custody that includes chronology of events, parent involvement log, calendar, reference times that you're available worksheet, the main thing, your parenting plan, and any other relevant documents, lists, tables, charts that might be relevant to your situation in court. You're going to need to prepare your case. So if you start thinking through all these custody-related scheduling issues and answer these in an objective, non-emotional way, then you're going to have taken a huge first step in the right direction. Divorce and custody, it's like having another full-time job. You're going to need to get organized and think about what's best for your child and what you want. Then you need to work your way through this horrendous process. One of the lessons you're going to learn is that there's a huge administrative component to the divorce process. It's better not to rely on your lawyer for every detail. The more you do, the less your lawyer does, and that alone is going to save you thousands of dollars. There are going to be many documents like declarations, income and expense statements, statements of assets and liabilities that you can create entirely on your own, or at least create the content for yourself. Don't use a lawyer to do this for you, as you're going to be needlessly running up legal bills that they're administrative. He doesn't know this stuff any better than you do. There's nothing in these documents that requires preparation by an attorney. Nothing. One of the things that I did that worked very well was to ask my attorney for 2 redacted copies of documents that I needed for court, and then I prepared them. My lawyer, I let him fine-tune it afterwards, but as opposed to having him create it from scratch, saved a lot of money. And I highly recommend this for everyone. If you know how to write, try to do as many of these things as possible. You can always check it later and you'll save $1 zillion. Now, this is true for contact logs, timelines, chronology of events, parent involvement log, calendar, references, all that kind of stuff. Remember, your lawyer works for you, okay? Let them do the legal work. But it's completely unnecessary for them to do administrative work, which is really the bulk of it. Family law is not rocket science. If you take the initiative and do your part, you can significantly reduce your legal bills. Now, what to expect from a typical day in court? You finally get all your paperwork together, your lawyer's prepared, you have a hearing at 8:30 along with 20 other people. The lawyer agrees to meet you at the courthouse at 7:45. You check in with the bailiff, only to find out there are 15 other cases that day. The judge doesn't even come out till 9:15, and then they start calling and hearing cases. So what do? You sit around. Next thing you know, it's lunchtime, and they've only heard 5 cases so far. So they tell you come back at 1:30, only to have a case which is pro per, meaning that one or both of the parents are representing themselves without legal counsel. And as they try to explain what they want, the judge keeps interjecting while explaining court protocol and procedures to them. You tell your attorney you'll be out in the hallway as it's too painful to even sit through. You hope he'll come out soon to get you when it's your turn for the case to be heard. And unfortunately, he never does. After an hour, you go back in. Next thing you know, it's 4:15. Judge informs you that they're not going to be able to get to your case that day. They ask you when you're available to come back, and the earliest date is 2 months out. So by the time you go back and forth with your ex, the 2 lawyers, the new mutually agreed upon date, it's 3 months away. You reluctantly agree and go home. Following week, you get a bill from your attorney for that day, $4,000. The detail explains it's for 9 hours, which includes their driving time, at an hourly rate of $500 per hour. And after you realize that you've accomplished absolutely nothing, moreover, you come to the realization that this very well could happen to you next time as well. The simple reality is that you're going to be paying your lawyer to sit around most of the time when you have to go to court. You originally budgeted $50,000 in divorce expenses for the entire divorce. Now you're starting to wonder. Now, that may be a colossal understatement, because now you're a victim of the system. You never calculated that you'd be paying for the inefficiencies of the court system. You don't want it, but that's the way it is. Hopefully, this is going to be your motivation to find a way to mediate or in some other way settle without a judge having to decide for you. Otherwise, it's likely to be a very expensive process and can be drawn out for years. Whew, so that's just an overview. Anyway, this is Joe Pastore with Platinum Method Coaching. I hope you found this informative. We have a ton of stuff here, so stick with me on this and we'll be back next time. Until then, make it a great day.